Ms. Martineau, it is your claim that the defendant, who was your landlord, refuses to return your security deposit on the premises that you were renting, and also that you were prematurely locked out of your residence, which caused you to leave some stuff inside the residence, so you want the return or the value of property.
Judge Judy sits upright in the judge's chair. In front of her are two people, two stories, but in reality, only one issue needs to be clarified. Her eyes sweep quickly from the plaintiff to the defendant. In that brief moment, she does not judge who is right or wrong. She looks for only one thing: the structure of the truth.
When did your lease begin?
It began February 1st, 2013.
So it ended January 31st.
2014.
Did you pay your rent every month, the first of the month?
Yes.
The plaintiff is Miss Martineau, a woman who shows neither agitation nor weakness. She stands there with the posture of someone mentally prepared to defend her rights with reason, not emotion. She rented the defendant's house under a lease that began on the 1st of February 2013, lasted 12 months, and ended on the 31st of January 2014. The final month's rent was paid in full. The security deposit she gave to the landlord was $1,500.
Mr. Wilson, my question is, did the plaintiff pay rent for the month of January of 2014?
Yes, she did.
The defendant is Mr. Wilson, the homeowner. He acknowledges the contract dates and admits he received the full payment for the final month's rent.
Of course.
However, he refuses to return the security deposit. According to him, the house required repairs and the tenant left personal property inside.
We didn't try and go into the property. There was another family already living in there, so we didn't want to just open the door to some other family.
On what date was there some other?
January 28th.
The dispute began on the 28th of January 2014.
I don't know who these people are. They're in my house.
When Miss Martineau returned to the house to retrieve her remaining belongings, she found the door locked and another family living inside. There was no official notice, no handover record, no opportunity for her to access her personal property. At today's hearing, the plaintiff's demand is clear: the full return of the $1,500 security deposit due to being locked out before the lease ended, and the unlawful retention of her personal property. The defendant argues that keeping the money was reasonable, that the house was damaged, and that allowing another tenant to move in did not violate his obligations. Judge Judy listens, but not in the usual way. She does not listen to empathize. She listens to identify the central axis of the story. In her mind, every case must be reduced to questions that can be answered with objective facts. There are no gray areas for dates, no gray areas for contracts. She begins with short questions. The lease start date, the end date, whether January rent was paid. Each question is delivered in an even tone, neither raised nor lowered. For Judge Judy, the rhythm of questioning is the rhythm of control. In her view, this is the most important phase not because the answers are difficult, but because the respondent's reactions reveal more than the answers themselves. The plaintiff answers succinctly and consistently. No embellishment, no detours. Her responses line up like neatly aligned dates.
The problem is there was a third party on the lease. That third party was paying cash and was not always paying on time.
Well, that's your problem if you accepted cash. That would be your problem, Mr. Wilson.
Well, then also,
my question is...
he never completed the payments.
Who never completed the payment?
The third party never
I
completed.
don't care about the third party.
The defendant is different. He begins talking about a third party, about cash, about late payments at other times. He speaks more than necessary, and in Judge Judy's mind, this is a familiar signal. When someone cannot keep their story within the frame of the question, it is usually because they are trying to pull it away from their weakness. Judge Judy does not interrupt immediately. She lets him speak. She has done this thousands of times. She knows that those who believe they are right will often dig deeper until the limits of their argument are exposed. Then she stops. She looks directly at the defendant and asks the question she has already identified as the pivotal point of the entire case.
Did the plaintiff pay rent for the month of January of 2014?
Yes, she did.
The answer is yes. In Judge Judy's inner world, a door closes. Once the final month's rent has been paid, Every action taken by the landlord before February, one must be viewed through a different lens. The law does not care about the landlord's inconvenience. The law cares only about the tenant's lawful right of possession. She does not need to react immediately. She simply notes it. For Judge Judy, the moment one side confirms its own weakness is often when the case has effectively ended, even if it continues formally. The story shifts to January 28, the day the plaintiff discovered someone else living in the house. Judge Judy asks who was living there on that day.
Who was living there in January and February of 2014?
February 1, there was a family that moved in.
Name.
Last name was, and they moved in February 1.
I'm not sure whether I believe you, Mr. Wilson.
I have a letter from Mr.
Oh, I'd like to see it. Richard moved in on the 28th of January.
Richard signed a lease on the 28th of January.
If Richard signed a lease on the 28th of January, show me the lease.
I don't have a lease for Richard for 28th of January.
A name is given, an explanation, a letter, but no contract, no documentation proving lawful occupancy while the original lease was still in effect. In Judge Judy's mind, this is the moment when petty power reveals itself, when someone believes that ownership allows flexibility with the law without proof. She has seen this pattern too many times to consider it an innocent mistake.
Now, I'd like to see pictures of the premises when the plaintiffs moved out and when the plaintiffs moved in.
There's no pictures of the property when the plaintiffs moved in.
Why not?
That's not something I tend to do.
She asks to see photographs of the property's condition at move-out. There are none. Not because they were lost, but because they were never taken. Judge Judy shows no disappointment, no anger. She simply slows down. When she speaks more slowly, it signals a shift from gathering information to drawing boundaries.
You kept their security deposit. You have to explain why you kept their security deposit.
I have all.
That statement is not personal. It is a principle. In her mind, this is the most important boundary in small civil disputes. Money cannot be kept simply because someone thinks they are right. The law does not operate on assumptions.
I have all the explanation.
Show me the photographs of when they moved out. You took these really nice pictures. These are lovely. Now show me the photographs of when they moved out.
I don't have photographs of when
Well,
they
that's a
moved out.
problem for you, Mr. Wilson. You have to return their security deposit. How much was
Your
your
Honor, I have a breakdown of
I'm
why.
not looking at your breakdown, sir.
Well,
You
could-
see how you took pictures of the
Do you
house
have a
after you
copy of-
picked it up? Listen to me. Do
I
you
understand,
see?
but do you have a copy of the lease?
Don't talk over me.
In Judge Judy's view, late arriving evidence does not increase credibility. It only shows preparation to justify, not to comply. Then the decisive moment appears. The defendant says he thought the tenant abandoned the belongings, that they seemed worthless. In the courtroom, no one reacts strongly. But in Judge Judy's mind, this is the end. Because when someone assumes the right to value another person's property, they cross from a legal boundary into a moral one. Judge Judy looks directly at the defendant and clearly states what he did wrong, not only contractually, but in terms of social order.
And you had no right to put somebody into the house because you therefore collected rent for a couple of days in January from two different tenants. You can't do that, Mr. Wilson. That's a no-no, sir.
In that moment, the power the defendant thought he held is completely stripped away, not through raised voices, but through absolute clarity.
This is America. You have choices. Go find someplace else to live. Judgment for the plaintiff in the amount of $1,500.
The judgment is delivered. $1,500. No further explanation is required. As the questioning deepens, Judge Judy's inner mind shifts to another level, the level of professional memory. This is no longer a single dispute, but a familiar variation of a pattern she has seen thousands of times over more than 3 decades on the bench. One property owner who believes ownership grants flexibility with the law, one weaker party forced to rely on the system rather than personal power. In her mind, past cases surface one by one. Apartments locked before leases ended, security deposits withheld for vague reasons, landlords saying they thought the tenant had left. The common denominator is always the same, not great malice, but a small, gradual slide of power. A thought that begins with, "I think I can do this." Judge Judy understands the danger of that mindset. If the court tolerates it even once, tomorrow it will repeat itself in another house, another lease, with another tenant who has less voice. Therefore, when she asks about the new tenant's lease on January 28, the question is not merely about documents. It is to determine whether the defendant ever stopped to ask himself, "Do I have the right to do this?" The climax arrives quietly. No shouting, no argument. It is when the defendant admits he had no lease for the new tenant on January 28. At that point, every piece falls into place. The landlord collected the final month's rent from the plaintiff while allowing another tenant to move in before the lease ended. No new lease, no move-out report, no condition photos, only a unilateral decision, driven by the belief that the other party would be unable to act. Judge Judy does not need to spell out the entire chain of reasoning. She only needs to ask one final, seemingly simple but locking question. So, in the final days of January, how many people did you collect rent from? It is a logical trap, not accusatory, not emotional, just mathematics. And mathematics does not negotiate. Internally, Judge Judy feels the boundary clearly drawn not between emotional right and wrong, but between ownership and legal responsibility. She does not see this as punishment. To her, it is a restoration of order, a message sent not only to those in the courtroom, but to anyone who believes small power can be used arbitrarily. The $1,500 ruling is therefore not just a number. In Judge Judy's mind, it is a necessary stopping point. In Judge Judy's thinking, it is a necessary halt not to punish, but to sever a chain of behavior that could continue indefinitely if not stopped. She has seen such chains escalate. Today a security deposit, tomorrow rent, and then other rights slowly eroded, all beginning because no one said stop early enough. It is the end of the "I think I can" mindset. A reminder that in this society, order is not maintained by goodwill, but by clear boundaries protected by law and reaffirmed daily in cases that seem very small. Judge Judy stands up, carrying the familiar fatigue of someone who has just done work that no one applauds, but without which everything would collapse. The hearing ends, but in her mind, she knows. Tomorrow, the pattern will appear again, and she will again ask short, cold, precise questions, not to appear harsh, but to keep society from slipping out of its own order.